The Walt Disney Company has been having a very horrible month. Just yesterday, an extremely important brand new lawsuit has hit the entertainment giant, and it is being filed by America's First Legal, or the AFL, and they are alleging that Disney's diversity, equity, and inclusion, otherwise known as DEI initiatives, constitutes illegal discrimination against white American men in violation of the 1964 Civil Rights Act. The complaint is centering on Disney's hiring and promotion practices, which the AFL is claiming are biased in favor of underrepresented groups, including Black, Latino, and the LGBTQIA plus individuals, at the expense of white men, Christians, and Jews. The idea here is that the DEI efforts in hiring and promotion are inherently discriminatory and illegal under federal law. Now, the AFL in their lawsuit are referencing internal Disney documents, including a memo outlining the company's inclusion standards. These standards have been criticized by public figures like Elon Musk, who has described them as, quote, mandatory institutionalized racism and sexism. And Musk, by the way, has also offered to fund legal battles for individuals who believe that they have been adversely affected by Disney's racist DEI policies. Now, America First Legal's lawsuit is part of a larger trend on legal challenges against DEI initiatives following the U.S. Supreme Court's ruling against affirmative action in higher education. This ruling has also raised concerns among corporate leaders about the legality of their DEI programs and the potential for increased scrutiny and legal challenges. The AFL's actions here, including this lawsuit against Disney, reflect a concerted effort to oppose what they view as illegal race and sex-based discrimination in employment practices. But what blows my mind about all of this is, how could they not have seen this coming? We already went through the civil rights era, where clearly the idea of using race or sex as a way to qualify or disqualify someone is inherently wrong. So the question arises, how on earth did we get to this place? Well, I believe that all of this stems from the abhorrent ideology that racism only exists as long as it comes from white people. You see, this new evil philosophy has been associated with the rise in critical race theory and some social justice movements. These emphasize the role of systemic power and privilege in defining racism. The idea is that somehow racism only counts or is only real if, and only if, there is institutional power to enforce said racism. Now, this, of course, is a stupid and dangerous idea, but unfortunately, it has taken root in many people in Western culture today. This is how you get idiotic terms like reverse racism, as if there is any kind of racism other than racism. Anyway, back to the lawsuit here. This legal challenge comes amid broader debates over the role and legality of DEI initiatives in the workplace. Proponents of DEI, though, argue that such efforts are necessary to address historical inequities and create more inclusive work environments. But the reality is, initiatives like that of Disney's DEI program will inevitably result in unfair hiring and promotion practices that will prioritize certain groups over others based on race, gender, and sexual orientation, which again is in violation of federal law. Now, if this lawsuit against Disney for its hiring practices is successful, there will almost certainly be significant consequences, both for Disney and for DEI initiatives all across the United States. For Disney, there will be legal and financial implications if they lose. One of these will be mandatory changes to hiring practices. If they lose this lawsuit, Disney would almost certainly be required to revise its hiring and promotion policies to ensure that they comply with federal anti-discrimination laws, particularly the Civil Rights Act of 1964. This would involve eliminating specific quotas or preferences based on race, gender, or sexual orientation. Then Disney could be looking at financial penalties, depending on the specifics of the lawsuit's outcome. They could face financial penalties which might include fines or damages awarded to plaintiffs who were deemed to have been discriminated against under the company's DEI policies. And then when it comes to the broader implications for DEI initiatives everywhere, you could expect to see a chilling effect on DEI programs. A successful lawsuit would mean that the DEI initiatives across various industries would have to be reviewed. Companies would become more cautious or scale back their DEI efforts due to fears of legal challenges, especially those related to hiring and promotion practices. Then there would be increased legal scrutiny, where the lawsuit could set a precedent that would subject DEI programs to increased review by the courts. This might encourage other groups or individuals to file similar lawsuits against these companies with the DEI initiatives, potentially leading to a reevaluation of how such programs are designed and implemented. This then would lead to a shift in corporate strategies. The companies would almost certainly seek alternative approaches to achieve diversity and inclusion that would not involve race-based or gender-based preferences. This could include focusing on socioeconomic status, first-generation college students, or other non-protected characteristics as proxies for their desire of diversity. Which then brings me to the impact on the workplace. Companies would need to reevaluate how they measured and reported on diversity, moving away from specific demographic targets to more qualitative assessments of inclusivity and belonging within the workplace. There would also be a societal and cultural impact if this lawsuit were successful. You could expect to see intense public debates on the role and legality of DEI initiatives. The idea that we hire people based on anything other than their qualifications and/or performance is cancer in our society. If you want to put an end to racism, well then stop judging people by the color of their skin. The bottom line here is, a successful lawsuit against Disney could have wide-ranging implications here, affecting not only Disney's policies and financial standing, but also shaping the future of DEI initiatives across the corporate world. I don't know about you, my friends, but I am so very, very tired of seeing this hyper-focus on DEI policies that only serve to contribute to further division in our society rather than the unity that it was supposedly going to create. DEI is a low IQ approach to this issue, and it spits in the face of people like Dr. Martin Luther King Jr., who famously said, "I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character." Dr. Martin Luther King had expressed hope for a society that would one day rise above racial discrimination and segregation, and instead envisioned a world where all individuals would be viewed with fairness and justice. The reality is, people looking for work and getting promoted within their jobs should only ever be evaluated on their merit and personal achievements rather than some ancestry or immutable characteristics that they can never control. But in any case, this lawsuit is now getting started, and I, for one, will be watching this with interest as the case moves forward. And that, my friends, will bring this episode to a close once more. From the To Be Frank show, I am Adrian. Thanks for watching, my friends. I'll see you all next time.